My name is Michelle Goodwin, and I direct the Center for Biotechnology and Global Health Policy at the University of California, Irvine, where I'm a Chancellor's Professor of Law. It's my pleasure to have you all here at the National Press Club and our esteemed guest and panelist for the reproductive justice hearing. Our next panel of witnesses will discuss criminal punishment and civil regulation of pregnant women. Our session is being chaired by Judge Lynn Riddle. Also with Judge Riddle is Professor Aziza Ahmad and also Dr. Patricia Jones-Blessman. Judge Riddle.
Good morning to the panel, and I'm looking forward to all your presentations. Ms. Fettig, will you start us off, please?
Yeah, thank you. My name is Amy Fettig, and I am Senior Staff Counsel at the ACLU's National Prison Project, and I also direct our campaign to stop solitary. My colleagues and I at the ACLU have represented thousands of women and girls who are incarcerated in this country over the years, and I strongly wish that you could hear directly from these women impacted by the criminal justice system today. But I am proud and honored to try and convey the very real and urgent needs and sometimes insurmountable barriers that my clients face on a daily basis to try to ensure that their health care needs and their reproductive needs are met in the criminal justice system. I'm also pleased today to be here to ensure that the reproductive and healthcare rights of women and girls in the criminal justice system are included in this very important national conversation about reproductive justice in this country. Too frequently, these women's lives have been left out of the equation, ignored, discounted, or dismissed. Locked out and silenced is an all too apt title for this hearing, perhaps especially for women in the criminal justice system, but certainly not exclusively. My clients are amongst the most vulnerable women and girls in America. Very few enjoyed the protections that race, class, or economic status can lend to a woman in this country. When we look at the reproductive and health care rights of women in the criminal justice system, we can see the baseline status of women in America, and it's not pretty. In the last few years, we've seen a renewed assault on reproductive rights for all women, but the truth is that for too many women, those rights were always fragile or non-existent. The incredibly important task for us now is to secure reproductive and health care rights for every woman and girl in this country, regardless of race, class, economic status, age, or involvement in the criminal justice system. So today I want to focus on the unique barriers that women and girls in the criminal justice system face to securing their health care and reproductive rights. And I want to focus particularly on practices that undermine those rights and their human dignity. Practices that are happening at this very moment as we sit in this hearing room today. Specifically, I will focus on the shackling of pregnant women, the use of solitary confinement on pregnant women, and the denial of access to abortion rights that every incarcerated woman faces. First, though, I think it's critical to understand that the situation of women behind bars in America. Most people don't know that women represent the fastest growing proportion of the incarcerated population in the United States. Their numbers grew by over 587% between 1980 and 2011, a rate 50% higher than the growth rate of the male population. There are now over 200,000 women incarcerated in this country on any given day, and that does not include the thousands more of girls who cycle through the juvenile justice system on a yearly basis. Now, this massive increase in the number of incarcerated women has disproportionately been fueled by the detention of women of color, poor women, women with mental health problems, and histories of trauma and abuse. The drug war has fueled this increase so that most women behind bars today are there for nonviolent offenses like drug crimes or property crimes. And most incarcerated women are also mothers. The overwhelming majority of incarcerated women were the primary caretakers of their children before arrest. Now, incarcerated women face unique, sometimes overwhelming barriers to health care. And part of the reason for this is because the criminal justice system is based on the needs of men, the concerns of men, and it's largely run by men. In these systems, women face enormous barriers to care despite the fact that they have significant health care needs, a high prevalence of very serious medical needs like high blood pressure, asthma, hepatitis, HIV and AIDS, and sexually transmitted infections. And too many also have histories of addiction and substance abuse that actually go untreated while they are incarcerated. Additionally, as I mentioned before, a staggering proportion of women who are behind bars suffer serious mental health care problems that are often precipitated by long histories of trauma and abuse before they were arrested. Now, all of these factors of abuse and deprivation are important to remember as we consider the unique rights violations that women face in the criminal justice system. I want to first focus on the dangerous and inhumane practice of shackling pregnant women. You heard a little bit about this from Dr. Suffren in the previous panel. I want to tell you about a client of the ACLU, Megan Rydell. We filed suit on her behalf last month. Now, Megan was once a prisoner in Jackson County, Missouri, and she was pregnant. She had a very high-risk pregnancy, and when she went into labor, instead of taking her immediately to the hospital, the prison decided that they were going to drive her over 200 miles while she was in active labor. And this occurred after physicians had warned the officers about the high-risk nature of her pregnancy and the fact that her active labor was imminent. So she spends 200 miles, hours, bleeding, vomiting, in severe pain, and the entire time she was chained. Other women in the United States suffer the same fate. They're shackled by their hands and their arms while they give birth to their children. It is astonishing in a country that purports to honor human rights with a history of slavery that there are still babies born to mothers and chained in this country. As you heard before, shackling is extremely medically dangerous. The AMA, the American College of Gynecologists have all spoken out against this practice, said that it should be banned. We have federal court cases finding it unconstitutional. International human rights standards tell us that it's wrong, ban it in the international human rights context, and yet it's still practiced widely today. 22 states and the District of Columbia have outlawed the practice, but sadly, even in those states that have laws, and I know you'll hear more about this from Soffiyah, we found that even with laws on the books, they don't get enforced. Women are still shackled. Quite frankly, this practice needs to be banned in every state and jurisdiction in America. And there's also another practice that needs to be banned, and that's the solitary confinement of pregnant women in this country. I'm going to tell you a little bit about Maria, a woman we spoke to from Illinois. She was pregnant in jail. She had a history of depression because she was pregnant. She was taken off her antidepressant medications. She got slow. She needed more sleep. One day, an officer decided she didn't move quite fast enough at mealtime, and so he gave her a disciplinary infraction. And too frequently, what that means for prisoners in this country is they end up in solitary confinement, not because they're violent, but because they violated some rule. While she was there, like most pregnant women, she suffered isolation, extreme isolation, and anxiety. She was denied almost all human contact. She could not get access to the medical care that she needed. And as a result, she was put at great risk, as was her pregnancy, because of increased stress and the increased medical harms that especially imposes on pregnant women. Now, solitary confinement is a common practice in this country. It happens all too frequently. About 80 to 100,000 people are in solitary confinement at any given day. And unfortunately, too many of the people there, like pregnant women, are vulnerable populations. We know that it harms people, and yet we continue to do it, and we've known this for a very, very long time. Quite frankly, we have to ban this practice. We should ban it for everybody, but there is no question that no pregnant woman should ever be put into solitary confinement in this country. We have a lot to do, but it doesn't end there. Incarcerated women also face fundamental violations of their bodily integrity and basic life choices, and I'm talking about abortion access. Now, women's constitutionally protected right to abortion actually survives incarceration, and courts have consistently rejected corrections policies that categorically prohibit incarcerated women from exercising their right to abortion. And almost all courts to actually look at this issue have found it unconstitutional for jails and prisons to require women to get a court order to get an abortion. But in practice, there's a different story. Too frequently, incarcerated women and girls find that their jailers get to decide their most intimate life choices. Essentially, their jailers get to decide what they do with their uterus, not based on law, but on the whim or personal choice of an individual in power. This violation of women's rights happens for several reasons. First, despite court decisions, we often see prisons and jails requiring women to get a court order. You know how hard it is to get a court order from prison, especially even to get a lawyer? Almost impossible. Second, not all courts have said that abortion access for incarcerated women it can't be conditioned on their ability to pay. So women who are in jail are charged thousands and thousands of dollars in order to get an abortion. If they had that much money, they probably wouldn't be in prison in this country. And finally, there's a lack of clear policies around abortion access for incarcerated women and girls. So in a number of states and jurisdictions, there aren't even policies on the books telling corrections officials what to do about abortion access. So in this country right now, we must ensure that all women and girls behind bars can freely and safely exercise their abortion rights while incarcerated. So today I've outlined a few of the dire violations of reproductive and healthcare rights women and girls face in the criminal justice system. And there's much more to talk about. I'm looking forward to your questions from the panel. But I would say, in closing, that we can, we must, and we will do better. Thank you.
Thank you, Ms. Elijah.
Good morning. I'm Soffiyah Elijah, and I'm the Executive Director of the Correctional Association of New York. Founded in 1844, the Correctional Association of New York, or CA, is an independent, not-for-profit organization that advocates for more humane and effective criminal and youth justice systems and a more just and equitable society. In 1846, the CA was granted by the New York State Legislature the right to inspect prisons, monitor the conditions therein, and report its findings to the elected officials and to the general public. So we've been doing that for over 170 years. The CA is one of only 2 independent organizations in the entire country with legislative authority to monitor prison conditions. The only private organization in New York with unrestricted access to prisons. The CA has remained steadfast in its commitment to inform the public debate on criminal and youth justice systems. The CA utilizes its unique legislative mandate to expose abusive practices, educate the public and policymakers about what goes on behind prison walls, and advocate for systemic change that is progressive. The CA's Women in Prison Project was founded in 1991, and it was founded to address the fact that women's needs inside prisons were being ignored and marginalized. It focuses and tries to ensure that prison conditions for women are as humane and just as possible, and create a criminal justice system that treats women and all people with fairness, dignity, and justice. Our Women in Prison Project, or WIP, its main policy campaigns center on advancing reproductive justice for incarcerated women and transforming the criminal justice system's response to domestic violence survivors who act to protect themselves. Utilizing the organization's legislative mandate to monitor prisons, WIP conducts visits to and reports on conditions in New York State's correctional facilities that house women. In 2009, the WIP and the Correctional Association was successful in getting then Governor David Paterson to pass a law called the Anti Shackling Law, to which Amy referenced earlier. And that law covered all state facilities and local jails and prohibited the practice of restraining or shackling women during childbirth and immediately thereafter. It was intended at least to protect women during their delivery and hospitalization immediately thereafter. Unfortunately, based on surveys and interviews that the Women in Prison Project conducted when we interviewed 27 women who had given birth in the Department of Corrections after the law had been enacted, we found that 23 of those 27 women had in fact been shackled during childbirth. So in fact, we found that the Department of Corrections was not in compliance with the law. In addressing these concerns, we recognized also that two of the most common situations involving shackling are trips for medical appointments, which can happen weekly as a pregnant woman nears her delivery date, and trips between prisons, which can take more than 10 hours. So for example, in New York State, a trip from Albion Prison, which is located in the Western region, to Bedford Hills, which is very close to New York City, can take up to 10 hours and is about a 200-mile trip. So in light of the dangers that a woman faces from restraints when she's pregnant, we've pushed now for an additional law which would ban the practice of shackling women during all 3 trimesters of their pregnancy. We're pleased to report that that bill passed just the Assembly and the Senate in the last legislative session, and we are now waiting for Governor Cuomo to sign the law. Needless to say, we're advocating aggressively to get him to do that. This year, we issued a groundbreaking report called our Reproductive Injustice Report. For those of you who are interested in weight, it's 200 pages long, but there are executive summaries available for everybody outside. The report, entitled in full Reproductive Injustice, the State of Reproductive Health Care for Women in New York State Prison, as I said, is a groundbreaking contribution to this work. At 200-plus pages, the report outlines the problems facing women in New York State correctional facilities and makes recommendations for how docs and the state government can address these issues, all in the context of reducing incarceration in general and seeking alternatives to prison for women. Our methodology was to interview scores of women, over 900 women between 2009 and 2013, using a variety of survey methods and in-person interviews and reviewing medical records of those women, also interviewing staff. We distribute approximately 4,600 surveys and received back approximately 1,500. About a third of the women that we sent surveys to responded. Some of our findings included the following. We found first that there are virtually no oversight reproductive health care standards or written policies and inadequate data collection and analysis by docs. Docs has failed to establish any systematic review of its reproductive health services, and the State Department of Health plays no role in evaluating reproductive health care in prison. Many prisons could not supply even the most basic information about reproductive health care and outcomes. Docs' written reproductive health policies are not comprehensive. They fail to reference community standards and deviate from those standards in key ways. While DOCS has made progress in curtailing the use of restraints after women arrive at the hospital until they give birth, women continue to be shackled on the way to the hospital, even when they are in labor, during recovery, and afterwards, and on the way back to the prison after they have been discharged. This is true even for women who have had a C-section delivery. In addition, every woman the CA heard from was shackled when they went on trips outside the prison during their pregnancy. Women described their experiences with shackling as painful, horrible, and degrading. We also focused on HIV, AIDS, and hepatitis C treatment, and we've just issued another report focused on those issues. We found that 54% of the women in New York State prisons have a serious or chronic illness, and about 12% of them are living with HIV, and another 17% have hepatitis C. These rates are significantly higher than what we find in the general public. Most women said that someone in DOCS had spoken with them about HIV or STDs, and this likely reflects the good work of the Criminal Justice Initiative. However, it is clear to us that much more needs to be done. Some good news: DOCS seems to be doing a solid job providing opportunities for HIV testing. Nearly all HIV surveyed respondents, 98% in fact, said they had been tested for HIV at least once since entering DOC's custody. One of the serious concerns that we have, particularly in New York State, is the largest state of any. It has the largest number of HIV positive people in its prison system and the second largest number of HIV positive women in its system. I want to share with you some of the recommendations that we made. The first one is that DOCs must develop a comprehensive written reproductive health policy that mirrors and references community standards, collects and analyzes reproductive health data, and conducts regular assessments of reproductive health services at each prison. It must comply immediately with all provisions of the 2009 Anti Shackling Law and eliminate the use of shackles on women during all 3 trimesters of pregnancy. It must improve basic conditions for pregnant women, including providing adequate food, supportive services, and creating a separate pregnancy housing unit at Bedford Hills. In total, we made 10 recommendations, but in the interest of time, I won't share all of them. You can read them in the executive summary. I will conclude by saying that for us, the fight for reproductive rights includes advocating for women behind bars. The American Medical Association reported that between 5 and 10% of women are pregnant when they enter a correctional facility. According to the Sentencing Project, 1 in 19 Black women is likely to be incarcerated, compared with 1 in 118 white women. We must address the racial impact of the need for reproductive justice, advocate for a humane system, and challenge the punishment paradigm that diminishes our current approach in criminal justice. Thank you.
Thank you, Ms. Elijah. Ms. Diaz-Tello?
Good morning, and thank you to the chairwoman and the chancellors and Professor Goodwin and the Reproductive Justice Initiative for their attention to these issues that are so often sidelined. It's been more than 4 decades since the United States Supreme Court declared that the Constitution's guarantees of liberty, equality, and due process apply with equal force to women. It has been 50 years since the court recognized the vital importance of the sexual and reproductive decisions that are so integral to who we are as individuals. And despite increasing obstacles and challenges, it has been more than 40 years since the court affirmed that people who become pregnant have a fundamental right to self-determination. Our society recognizes, at least nominally, that motherhood and the role of women in procreation should not be the basis for discrimination nor restrict full participation of women in society. But even as our constitutional jurisprudence moves toward a recognition of women's equal entitlement to status under the law, at the state level, criminal and civil child welfare prosecutions threaten to return us to the days when the capacity for pregnancy was used as justification for excluding women from every part of public life, from the workplace to higher education to public service. We hear often about the challenges that people face in preventing and ending pregnancies, and these challenges don't end when they attempt to carry a pregnancy to term. Increasingly, people who become pregnant face a landscape of legal pitfalls and threats to their rights and dignity. In the name of protecting the unborn, we have devised a system that is now creating new crimes that only pregnant women can commit. In 2014, the state of Tennessee became the first state to pass a law making it a crime for women to carry pregnancies to term after having engaged in any unlawful act or unlawful omission, specifically if they are unable to guarantee that those babies will not test positive for a controlled substance. While ingesting criminalized drugs is not a crime in the state of Tennessee, nor in most states, giving birth to a baby who shows the treatable and transitory symptoms of neonatal abstinence syndrome is now the crime of assault in Tennessee. Already, we have heard from women who are forced into hiding, afraid of arrest if they give birth and are detected, or if they reveal their situation to healthcare providers. Instead of seeking the help that they need, which is scarce and inaccessible across the state, they are left to cross state lines or terminate pregnancies to avoid arrest. Tennessee may have been the first state to pass such a law, but it was neither the first nor the last to try. Just this past spring, 5 other US states considered, and fortunately declined to pass, copycat bills that would make a pregnant woman's ingestion of a controlled substance an assault or another offense against the fetus that she carries. Tennessee and Alabama considered proposals that would increase surveillance and sweep more women into their criminal prosecution regimes. These bills failed because of the unanimous accord among medical and public health professionals that the threats of criminal prosecution drives women away from prenatal care and ultimately harms women and babies. One of the states to consider such a law was Arkansas, where just last month, at least 3 women were released from wrongful convictions carrying 20-year prison sentences. Prosecutors in that state, apparently unconcerned with the dire warnings of the medical community, took it upon themselves to arrest and charge women with a poisoning crime, introducing a controlled substance into the body of another person, if they gave birth to babies who tested positive for illicit controlled substances at birth. One such woman was Melissa McCann Arms, who had made great strides in her substance dependency treatment and was being reunited with her healthy 10-month-old child by child welfare authorities when she was arrested and imprisoned. The state argued that in the moments after birth, she introduced a controlled substance into the body of her newborn through the umbilical cord in the seconds before it was cut. Fortunately, she was freed by the state's highest court, which ruled that a law intended to punish people for dosing others with knockout drugs can't be used to punish women for the involuntary movement of controlled substances through their bloodstream. But the courts cannot always be relied upon as a bulwark against these injustices. And even today, the fate of Stephanie Luke lies in the hands of the West Virginia Supreme Court of Appeals. Ms. Luke was convicted of child neglect leading to death and faces a 15-year sentence after she experienced a cardiac arrest during a drug overdose, and her baby was delivered prematurely by cesarean surgery. In her case, the state is arguing that creating a risk to her own health is tantamount to endangering a child, and that any adverse outcome should be punished as a homicide. An affirmation of this interpretation of the law would not just affect women who ingest criminalized drugs, it would threaten any woman who undertakes any health risk, whether that be having uncontrolled diabetes, stepping on a ladder, or disagreeing with advice to have cesarean surgery, because virtually anything she does can have an impact on the outcome of her pregnancy. It's all too easy to dismiss these as cases of individual prosecutorial overreach, but the data tell a different story. Our executive director, Lynn Paltrow, and our board president, Dr. Jean Flavin, published a study in the Journal of Health Politics, Policy, and Law that found 413 cases from 1973 to 2005 from across the country in which pregnancy or a recent birth was the precipitating factor in a deprivation of liberty, including arrest, detention, or forced medical intervention. These arrests have come from nearly every state in the nation and have continued apace to the current day, with at least 800 more to the present day. Based on our research methods, we know that this is an undercount and that the actual figure may be 4 or 5 times larger. Nearly 500 of those known arrests come from the state of Alabama, where in 2013, the state Supreme Court reinterpreted a chemical endangerment law passed in 2006 to keep children away from the manufacture of methamphetamine, to punish women for exposing fetuses to the dangerous environment of their pregnant bodies. This law criminalizes any woman who uses any amount of a controlled substance, illicit or prescribed, at any point in pregnancy. In the concurring opinions, the justices are transparent about their contempt for Roe versus Wade and its recognition that it is impossible to award fetuses all the legal rights of juridical persons while maintaining the fundamental rights of the pregnant person. In its most recent ruling on the subject, one justice asked, why should the legal protection of an individual at a particular point in time depend entirely upon his or her subjective relationship to the killer? The message is clear. This is not just about drugs. This is about laying the groundwork to hold women criminally accountable for abortions and pregnancy losses. Alabama and Tennessee are case in point that what may seem like prosecutorial bad apples become the law of the land in the hands of activist judges and misguided legislatures. And no sooner do the courts strike down these illegal convictions than prosecutors find novel arguments and new crimes to charge women for the exact same thing. The effect is a treadmill of injustice from which there is virtually no safe haven. And across our divided states, red, blue, and in between, pregnant women are politically expedient targets, and more so if they are marginalized because of their race or socioeconomic status. It is no surprise then that we have the largest prison population on the face of the planet, and the fastest growing population in our prisons is women, with a 7-fold increase since the 1970s. Even more insidious is the corrosive effect of these arrests on maternity care. From providing legal cover to providers who coerce and force their patients into unwanted tests, exams, and even surgery, to outright conscripting healthcare providers as agents of surveillance for law enforcement, introducing prosecutors into doctors' offices and delivery rooms, destroys confidentiality and degrades autonomy for pregnant patients. As we speak right now, a jury in Virginia is deciding whether a physician will be held legally accountable in tort for threatening and coercing a patient with threats of child welfare interventions and court-ordered surgeries until she capitulated and consented to an unwanted cesarean surgery. He argued that he had a duty to protect the unborn, even by violence and forced surgery against the woman who was carrying the child. Women's struggle to retain control of their reproductive lives when they wish to not be pregnant remains critical, and the reproductive justice framework tells us that we can leave no one behind. We work toward a world in which every pregnant person is free from violence from the state or private actors, and people retain their human rights and dignity throughout pregnancy. We appreciate your time and the opportunity to bring attention to this issue.
Thank you, Ms. Diaz. Ms. Ocen?
Thank you. Thank you to the Honorable Lynn Riddle, Dr. Patricia Jones-Blessman, and Aziz Ahmed. Thank you so much for the opportunity to be here. And I also want to thank Professor Michelle Goodwin, the Center for Biotechnology and Global Health Policy, for the opportunity to speak to you about the dehumanizing practices confronted by incarcerated women, and for your leadership in bringing these distinguished advocates together to highlight the burdens placed upon women's reproductive autonomy more generally. My name is Priscilla Ocen, and I'm an associate professor of law at Loyola Law School in Los Angeles, where I teach criminal law, family law, and a seminar on race, gender, and the law. As a scholar, I have explored the reproductive abuses experienced by incarcerated women. And in my time today, I will focus on the particularly degrading and the particularly dehumanizing practice that you've heard quite a bit about today of shackling of pregnant women during labor, delivery, and or postpartum recovery. But shackling is really only the tip of the iceberg in terms of the degrading experiences that women confront while incarcerated. And if I have time, I will also discuss sterilization and the termination of parental rights that so often accompany a prison sentence. Across the country, as you heard, pregnant women are routinely shackled at the legs, hands, stomach, and ankles in prisons and jails across the country. Pregnant prisoners are shackled during doctor's visits, while in labor, during delivery, and while in recovery. Such restraints are often applied by prison or jail guards as a matter of course, regardless of whether they have a particular history of flight risk or of violence. Shackles are routinely used on pregnant women who have not been convicted of any kind of a crime, such as immigration detainees and pretrial detainees. Shackles are routinely used on pregnant women who have been convicted of nonviolent offenses, such as drug or property crimes. And they're routinely used on women during active labor when, obviously, and as we've repeatedly heard, women are the least likely to pose a flight risk or a danger to themselves or others. The pregnant prisoners who are shackled, however, are not mere statistics. Despite the ways in which our criminal justice system seeks to erase incarcerated women and render them invisible, the women who are subjected to this practice of shackling are real people and suffer real harm and real consequences from this practice and experience real trauma. They are pregnant prisoners such as Simone Jackson, Juana Venegas, and Shawanna Nelson, who I'll tell you about in just a moment. Simone Jackson was an African-American woman arrested for a nonviolent offense in Chicago, Illinois. She was detained in the Cook County Women's Jail while awaiting trial and was pregnant at the time. At the time of her arrest and detention. Shortly after arriving in the jail, Ms. Jackson went into labor. Despite her obvious pain and discomfort, she was shackled by her wrist and ankle throughout labor and recovery. Later, reflecting on the experience, and I'm quoting her here, she said, "I thought, I'm in slavery." Troublingly, Ms. Jackson was shackled despite a state law prohibiting the use of restraints on pregnant women during labor and delivery. Ms. Jackson's experience, however, is not unique. Juana Villegas was similarly shackled during labor and delivery after she was held for an immigration violation. Ms. Villegas was almost 9 months pregnant at the time that she was detained. 2 days after her initial detention, Ms. Villegas went into labor. During her transport to the hospital, she was shackled at her hands and at her ankles. The shackles remained during labor despite repeated requests by the medical staff that they be removed. After giving birth, Villegas was shackled to the hospital bedpost. And I'm quoting her here. She says, "When I was in bed, I was begging the sheriff, please let me free, at least one hand. And he said no. He said he didn't want to." The shackles limited her range of movement and made it difficult for her to interact with her newborn baby after it was born. Shawanna Nelson was 27 years old, and she's an African-American woman who was serving a sentence for check fraud in an Arkansas state prison. It was her first criminal offense. She was 6 months pregnant at the time that she was in prison, and 3 months later, she went into labor. She was authorized to receive a transfer to a county hospital, and according to one nurse, she could barely even walk. She was in so much pain. She was placed in a wheelchair where she was shackled at the arm and at the ankle. Once she was admitted to the hospital, she was once again shackled. She was shackled throughout labor. And she was shackled despite the fact that a guard reported, and I'm quoting the guard here, that she never felt threatened by Nelson at any time. As a result of the use of shackles, Ms. Nelson suffered significant pain and injury, including the displacement of her hip. Because of these injuries, Ms. Nelson can no longer play with her children, she can no longer play sports, or bear weight on the injured hip. Ms. Nelson's doctors have advised her not to have any more children because of her injuries. As the stories of Simone Jackson, Juana Villegas, and Shawanna Nelson demonstrate, the harms of shackling of pregnant prisoners during labor, childbirth, and postpartum recovery are many, and you've heard others speak in more detail about that. And as you've also previously heard, the justifications are few. But the harms associated with shackling during labor, delivery, and postpartum recovery go well beyond physical injury. The use of shackles during pregnancy sends a symbolic message that the bodies of women prisoners are devalued, degraded, and dehumanized. The use of shackles on pregnant prisoners suggests that incarcerated women are unworthy of the basic human right of procreation and reproduction, that they are unfit for the basic respect accorded to others during the childbirthing process. The stigmatizing effects of shackling during labor and childbirth are particularly troubling, given that the women who are incarcerated, 2/3 of whom are women of color, have stereotypically been viewed as undeserving or unfit mothers. The application of shackling is a form of punishment for their choice to carry a pregnancy to term and to become mothers. So, shackling, however, again, as I said at the top of my remarks, is just the tip of the iceberg. The particularized punishments that pregnant women or parenting women confront while incarcerated are many and go well beyond shackling. For example, a recent report by the Center for Investigative Reporting conducted in conjunction with Justice Now found that over a 5-year period, over 150 women were sterilized in California state prisons. I want to tell you the story of a client of mine, Kimberly Jeffries, in the few minutes that I have. Kimberly Jeffries gave birth while she was a prisoner in the state of California. She was transferred to a county hospital that had contracted with the prison to provide care to pregnant women. While she was on the operating table for a cesarean section, the doctor asked her, as she was sedated, "So are we tying your tubes today?" Right, while she's sedated, while she's about to go under and experience a procedure, she's having to advocate for herself and ask the doctor not to engage in this procedure. To this date, she doesn't really know if she was actually sterilized. So this is one story out of many that we know of, where pregnant women who are incarcerated, where parenting women who are incarcerated are being denied the basic human right of procreation and parenting. I'll mention another way in which pregnant women and parenting women who are incarcerated, or women who wish to parent while incarcerated, are subject to particularized forms of punishment and particularized forms of reproductive devaluation. This particular form that I want to mention is through the termination of parental rights. under a federal law called the Adoption and Safe Families Act, there is a expedited timeline for the termination of parental rights, particularly for those, for women who, or parents who were the parents of minor children, particularly infants. There's a 22-month timeline. And for many women who are incarcerated, they're simply not able to, one, engage in communication with the court, to maintain contact with their children or their infants or other caregivers, and so they're more likely to lose their right to parent. This is particularly true given that the average time spent in prison for most women is 24 months. So you have a timeline for termination that is 22 months, and an average period of incarceration that's 24 months. So for many women, the fact of incarceration means that they no longer have access to their children and that they lose their right to parent. So I'll conclude here. I just got the signal that I'm out of time. So what do we need to do? We need to endeavor to provide compassionate and dignified care for all women, for all pregnant women, for all parenting women, for all women, period, regardless of who they are, regardless of where they're held in terms of incarceration. This needs to be our basic promise to women who are the most vulnerable. And I hope that this hearing is one step of many that will put us on that path. Thank you.
Thank you, Ms. Ocen. And Ms. Haimowitz, are you ready to proceed?
Yeah. Turn this my way. Okay. Thank you. My name is Rebecca Haimowitz. I'm a documentary filmmaker, and I'm the director and producer of a film whose working title is The Pregnancy Exclusion. The film tells the story of Marlise Munoz and a little-known law that's currently in effect in over 30 states in the country. I'm going to introduce this story, and then we're going to look at a 3-minute trailer of the film, and then I'll speak again about the film and the broader issue at hand. So Marlise Munoz was 33 years old and 14 weeks pregnant with her second child when she died. After suffering a pulmonary embolism, she was pronounced brain dead in a hospital in Fort Worth, Texas, which is not the same as a coma or persistent vegetative state. Brain dead is legally dead. Marlise and her husband, Eric, were both paramedics. So unlike probably many people, they'd actually talked about what they would want to do if they ever found themselves in a situation like this. And Marlise had been very clear. She did not want to be on life support ever, under any circumstances. Her family informed the hospital of this, but the hospital informed her husband and parents that of a little-known law called the Pregnancy Exclusion that states a person may not withdraw or withhold life-sustaining treatment from a pregnant patient. So despite her clear wishes, the hospital forced her to remain on life support. They would try to see if they could sustain and grow a pregnancy in a fetus in a woman who had, in fact, legally passed away. You may have heard this story. It was in the headlines a lot when it happened almost exactly 2 years ago. People were vigorously debating what's the right thing to do. On the one hand, many argued that if anything could be done to save this fetus, it should. Others felt that the state was imposing an unfair, even ghoulish mandate on this family, using a dead woman's body to incubate a fetus. Everyone had an opinion about what choice should be made, but the point is the family didn't have a choice. This law takes that choice away from women and those closest to them, and the effects, as we'll see, can really be devastating. So my documentary film follows Marlise Munoz's family from personal tragedy to unwanted media attention, and finally towards advocacy as they fight to change this law. Their story is a jumping off point to also discuss the larger issue about a growing trend of laws that take rights away from pregnant women, as we've heard some of which today. So I'd like to show you the trailer, and I want you to see the real people who are involved in this case, and then afterwards I'll talk about the broader scope and the big picture issue that the film hopes to address. Just take a minute.
You wake up every day thinking this is a bad dream. I'm gonna wake up any minute. And then when you wake up and you realize, I'm still here. I'm still in this hospital. This is real.
A pregnant woman caught in limbo between life and death, declared brain dead, and her family prevented from pulling the plug.
My wife was 14 weeks when this happened.
A person may not withdraw or withhold life-sustaining treatment from a pregnant patient.
She had told us, under no circumstance do I ever want to be on life support.
You hear people say, you're a monster, to you're going to hell. Why isn't he thinking about the baby? Literally accused me of murder.
This is a case of an overwhelmed father that may not want to be a parent to two children.
She is a corpse being used as an incubator. This is Orwellian. Let me finish. Let me finish.
I appreciate the hospital fighting to preserve that life and save that life.
This is not about pro-life, pro-choice. This is about the life of the person who's already expired.
If the hospital had not intervened, she would have died and the baby would have died with her. It's no abortion. I guess you let God be God at that point.
It's cruel to make a family have to see and touch and look at a family member in this condition.
Her hands went from, being pliable to very rigid, very stiff. You're seeing a body slowly deteriorate.
My fear is that this, in the more conservative states, will now be clarified to make darn sure that dead or alive, we're going to keep you plugged in.
This was our daughter. This was someone that had meaning in life.
Eric said, if there's nothing else I can do, then at least can we try to change this law so other families don't have to go through this? I just want to be a voice for other families.
I just don't think the government can make this decision for anybody.
If this is the rule, then every time a woman of childbearing age becomes deceased, then I guess they will ship her off to a facility and hook her up to machines and let her dead body gestate the fetus.
It was too late to do anything for our daughter, but we want to help alleviate any pain another family might have to go through, because I'm sure this is not going to be the only case.
People need to know about this. It's not right. You as a husband should have, as a family, whatever decision it is that you decide to take, you should have the right to make that decision. I'm not saying you should make the same decision I did or a different one. I'm just saying you should at least have that.
So you honor Marlise by getting this rectified.
We're going to fight this. This is not right.
So that's the trailer for the film, which is a work in progress. We're still in production. Marlise Munoz spent 62 days on forced life support. We actually may change the title of the film to 62 days, but we'll see. And over that time, it became clear that the fetus was not actually developing normally. The Munoz family sued the hospital, and eventually they were granted permission to remove Marlise from mechanical support. She passed away minutes later. She was declared dead minutes later. But that's not the end of this story, because this case touched a nerve with so many people and ignited politicians on both sides of the aisle. And Marlise's family, as we said at the end of the trailer, are fighting in her honor to change this law, but many others are working to strengthen it. They did not agree with the hospital's decision, the judge's decision for the hospital to remove her from life support. So this is really the beginning of this struggle, not the end. And the film that I'm making is capturing this now. In the film, I speak to legislators and advocates on both sides of the issue. I think it's important to sort of see what the motivations and goals are of people who support these laws, and there are many. Ultimately, I believe what we need to do is raise awareness on a national level. That's what I hope the film will do. When this case first made the news, I think many people thought it was just an anomaly, or perhaps this was unique specifically to Texas, but that's not the case. I certainly hadn't known until I began researching that there are now 32 states and counting with similar or identical laws to the pregnancy exclusion provision. These laws take personal medical decisions away from medical providers and their patients, or their patient's surrogate decision maker. The doctors at JPS Hospital were told by hospital administration that they needed to treat Ms. Munoz, despite the fact that it was medically futile to do so. And as Marlise's mother, Lynn Machado, says in an interview that I did with her in our film, the doctors weren't practicing medicine, they were practicing politics. The film asks, who do we want making these difficult personal medical decisions. Lawmakers, hospital administrators, politicians, or do we want to allow women and their loved ones to make these difficult and deeply personal decisions for themselves? People tend to think that the debate around reproductive justice or life issues is relegated only to abortion. But as this story and many of the other ones you've heard today shows, it's actually part of a host of laws that essentially create a second-class status for anyone with the capacity for pregnancy. My goal with this documentary is to raise awareness of this subject matter, to connect the Munoz's personal story with a much broader, much-needed conversation. So I thank you for allowing me to be part of this conversation today.
Thank you very much, Ms. Haimowitz. That was very moving. We're on to our question period. Do you have some questions, Ms. Ahmed?
Okay, yeah. Do either
Go right ahead.
Okay. Well, it's difficult not to come away from this panel without a bigger theme that's sort of emerged, which is that basically what's happening to women's health in prison and outside of prison goes against basic notions of dignity. It's against common sense. It's against medical expertise, and it's clearly animated by the desire to punish and ideas of parental unfitness, as you said, Professor Ocen. And I was just wondering if, I have a question for everyone too, but in a general way, if you could talk a little bit about what little bits of progress may have been made, and in this environment, which seems so dire, how has that happened? I was hoping that Ms. Fettig and Ms. Elijah could speak about young women, because you both mentioned young women a few times in your presentation. And I'd love to know what happened, Ms. Elijah, when you pushed after the Anti Shackling Law and found that the Department of Corrections did not actually stop shackling women. How did they react? Was it a good, did they respond appropriately? I don't know what an appropriate response to that would be exactly, but and I also was hoping, I got this, this question came to me with Ms. Diaz's presentation, which is, there's a deep tension between the hospital as a safe space and the hospital as the first step towards incarceration, or losing custody of your child, being treated without your, against your wishes that were explicitly stated. And I was wondering if you could speak to that tension. How, this seems to be specific to some groups of women in prison, women of color, poor women. Professor Ocen, I was hoping you could speak to the issue of the mental health consequences and stress in terms of losing one's parental rights in prison and in the context of pregnancy in prison. I was hoping, Ms. Haimowitz, if you could talk about the current political environment on changing this law. You said you had spoken to legislatures, so what's on the horizon, you think?
I think we could start with Ms. Haimowitz. We're still stunned by the film, and then come back to Ms. Ocen and go in that order. Thank you.
Sure. Yeah, well, so last spring, in April actually, there were two separate bills that were filed. I'll refer specifically to this case, and then I can talk briefly about sort of the broader national conversation. But in Texas, there were sort of dueling laws that were brought before the Texas House of Representatives. One with the support of Marlise's family, and the ACLU of Texas with Representative Elliot Neistat put forward a bill that they were calling Marlise's Law to try to remove pregnancy exclusion provisions from advance directives. Simultaneously, there was another bill that was put forward, and I don't want to get the title wrong, but it was the Protect the Unborn Child Act. I'm going to get it wrong. But importantly, the effect was that it would not only sort of strengthen these pregnancy exclusion provisions, it would put in language that it would explicitly apply to brain-dead women. It actually would just say brain-dead women. And that if there was any contention and any legal action taken, that a lawyer would be appointed to a fetus in any case, which we've seen in other states, Alabama specifically. So both those laws were presented. They both were left pending, and the way that it works in Texas, to my understanding, is that we won't even have another session for 2 more years. So I think they will be left pending for some time. But I think that they will be referred to. I think it's still going to be crucially important, particularly with an election year coming up, because this has become to take on symbolic meaning as well as very real meaning for women, or for anyone with the capacity for pregnancy. So I don't think it will be settled immediately. I think that, again, one of the reasons I'm making this film is I think people just thought this was this like freak incident that happened, or it was some sort of misunderstanding. The hospital to this day, that's their opinion. That's what they put forward as well. We weren't sure how to interpret this law. I don't want to sound cynical, but I don't think that was actually the case. I think that there really is a lot of intention behind this. So again, I don't know how it will. I don't think it will be immediately addressed legally, but I think it will be addressed sort of politically and needs to be. And I think people need to realize that it's not just Texas, it's more than half the states in the country.
So on the question of the trauma of parental loss, I want to give a little bit more context in terms of what women experience when they're incarcerated. So I think it was mentioned earlier that something like 80% of women who are incarcerated are the parents of minor children. Not only are they the parents, they were the primary caregivers of those children. And unlike men, because they were the primary caregiver, often when they're incarcerated, that means that their children either have to go to a grandparent or they're placed in foster care and given to someone who's either a member of the family or outside of the family. So that means that they are subject to these timelines where they are very much at risk of losing their child. Unlike men, they're not able to give it to another co-parent, give the child to another co-parent that would keep the child out of the foster care system. I also want to place this in the context of what's happening with women and their contacts with their families. There was one study that found that in a particular state, I think it was in California, over 70% of women did not get any visits from their family members. And often, what is required to maintain custody is sustained contact with one's child, either through letter writing, physical visits, et cetera. And so when you contrast the fact that so many women are primary caregivers, that their children may be in foster care, and that they have a very difficult time keeping contact with their children, that makes it very likely that they'll lose custody. This is also in the context of severe budget cuts, where programs are being eliminated from women's prisons, including drug treatment programs, parenting programs, and these are precisely the kinds of programs that women are required to take in order to maintain contact with their children and ultimately to reobtain custody of their children once they are released. And so their failure to adhere to these kinds of what's called family reunification plans often means that their parental rights will be terminated. So the fact of their incarceration, in terms of the length of the incarceration, increases the likelihood of incarceration. The familial dynamics and the distance often of prisons from urban centers like Los Angeles or New York, it's often hours and hours and hours to the closest women's prison, which makes it difficult for families to be connected. And the loss of sustained programming in prisons make it very likely for women to lose their children. And what's the emotional effect? It's significant. When I was a practicing civil rights attorney and we would go into prisons and jails to do legal visits, the number one issue was familial rights. The number one issue was parental rights. Many women didn't even know who their attorney was, or they couldn't get in touch with them. They didn't know what was going on in terms of proceedings. And women felt devastated. I mean, just for parents in the room, I'm sure you can imagine not knowing where your children are, what's going on with them, and whether or not you will be able to to continue to be in their lives as a legal matter. It's absolutely devastating, and I think we really undervalue and underappreciate the traumatic effect of incarceration in terms of the parental rights.
Thank you so much, Ms. Ocen. Ms. Fettig, can we come back to you now?
Sure. And actually, contrary to what most people think about the ACLU never having anything nice to say, I think there has been progress in the shackling of pregnant women. Horrible, awful practice, but 10 years ago, almost nobody knew that it was happening, even though it was going on around the country. And I really want to credit Shawanna Nelson, who was one of the first women to speak out and actually file a case challenging the fact that she'd been shackled during childbirth. We came in and represented her in front of the en banc 8th Circuit and ghost wrote that petition because the original court case said, oh, that doesn't violate the Constitution to shackle a woman during childbirth. But due to Shawanna's persistence, we now have case law that says it does violate the Eighth Amendment. It is cruel and unusual punishment to shackle a woman during childbirth in this country. But it didn't end there. Shawanna's courage really inspired advocates around the country. We started out with only 3 laws that actually regulated the practice of shackling back in 2007, and now there are 22 in the District of Columbia. It's imperfect. They need to be enforced more than they are, but we have laws on the books. And that's because women's rights advocates, prisoner rights advocates, and the faith community came together to speak out against this practice. We need to keep doing it, but it's a great example of how the intersectionality of groups and interests can be used to protect our most vulnerable individuals, like women and girls behind bars, but also to protect everybody. Because when we focus on the dehumanization of women, of pregnant women in this country, we also focus on the fact that it's not just certain women, but all women who are at risk. This is a fundamental devaluation of our lives as women. We are struggling against that. It's going to take work, but it's going to take work from all of us. And so it's great that we're here on this event now. I also want to say that in the solitary confinement context, again, it's a great example. This practice went on for decades in this country. Nobody paid attention to it, but recently it has become part of the national discourse. So I think we're going to see, and we are starting to see, this practice being reformed. And hopefully, in the not-too-distant future, we have New York as a case study, litigation settled, so that now pregnant women are, there's not a categorical ban, but there are protections against solitary confinement. Starting in New York, it needs to be in every single state across the country.
Thank you very much, Ms. Fettig. Brilliant answer. Ms. Elijah.
What progress has been made? Well, I guess if you think about the fact that the Correctional Association has been challenging the practices of docs, and that the union that represents the corrections officers just recently stated its support for the 2015 Anti Shackling bill, that's a big step in the right direction, because we challenge them a lot. But what else has happened that I say is progress? One of the things that I think is very important is that the voices of the women who are most impacted by these practices have moved up into the leadership in challenging these practices and are the advocates on the front lines speaking to our elected officials and to the public about what has happened to them. So for instance, in New York, when we were advocating around the first anti-shackling bill, the response of the department was disbelief. They didn't believe that it was happening. And we were benefited by the courageous women who had suffered from that practice to come forward to participate in video documentaries, to go to Albany, participate in lobby days, to go to district offices and talk to our elected officials, so that we are now at a point in 2015 where the new bill that would ban shackling in all 3 trimesters was unanimously passed in both the Senate and the Assembly. So I would say that that is progress. Obviously, there's a lot more that needs to be done, because despite the passage of the laws, we still have a problem with compliance. So there's good and there's bad.
Thank you. Ms. Diaz.
Professor Ahmed had asked about the tension between the hospital as a safe space and between it being the first step in the process of criminalization. And I think that the presumption of the hospital as a safe space is something that really only exists for certain people in our country. Theoretically, pregnant patients have all the same rights as everybody else. As a matter of constitutional law, unwarranted searches and seizures of searches of their bodily fluids through testing for purposes of law enforcement are unconstitutional. They have all the same rights under HIPAA, the rights to patient confidences, the ethical standards of the American Medical Association, the American College of Obstetricians and Gynecologists, all weigh very strongly in favor of protecting patient confidentiality. And yet, at the same time, the 2013 study that I referenced found that, in particular for Black women in the South, the most frequent source of a referral to law enforcement was somebody in a helping profession, so that doctors, nurses, social workers in the hospital setting. So what we really find is that the protections only exist to the extent that the person is perceived by the hospital to be compliant and to be good and virtuous person. And in fact, we have found in the cases that we worked on hospital policies that contradict people's statutory and even constitutional rights. So we ask not only for accountability by hospitals that turn their patients over to law enforcement and to child welfare authorities, but also a culture of resistance among those practitioners who understand that this is not good ethical practice.
I thank you so much, Ms. Diaz. I was so inspired by all of you, but I was inspired by Ms. Fettig's last comments about how inspired she was that Shawanna came forward and became an advocate against shackling, and that was such an effective ability. And I just want to thank you all for doing the same thing. All this morning's advocates have all inspired us to take more action to preserve women's reproductive and healthcare rights, and I thank you so much.